So good afternoon, everyone. I'm delighted to welcome you 2024 Eli Lauterpacht Lecture. The lecture series was established in 2017 to celebrate the life and work of Sir Eli Lauterpacht. It provides all of us in Cambridge and in the wider community the chance to pay tribute to Sir Eli's contribution to international law, not least of which is the founding of the centre in which we find ourselves today. The series was made possible by long-time friends of the centre, Dr. Ivan Berkowitz, who was in fact one of Sir Eli's students, and Mrs. Francesca Berkowitz, and we're grateful to them both. It's a real pleasure to introduce the 2024 Eli Lauterpacht lecturer, Judge Patrick Robinson. As all of you will know, Judge Robinson has had a distinguished career in international law. Most recently, he was a judge of the International Court of Justice, completing his term in February of this year. Before that, he was a judge and later president of the International Criminal Tribunal for the former Yugoslavia. He's been a member and president of the Inter-American Commission on Human Rights, a member of the International Law Commission, and was for more than 25 years Jamaica's representative to the 6th Committee of the United Nations General Assembly. He will be speaking today on the highly topical issue of the right to self-determination, Chagos, the Caribbean, and the occupied Palestinian territory. He will speak for around 45 minutes, and he's kindly agreed to take a few questions following his lecture. Judge Robinson, we are delighted to welcome you here. The floor is yours.
Mr. Standish Sivakumaran, the director of the Center, ladies and gentlemen, having arrived at Middle Temple in 1966 to read for the bar, I studied carefully the book list to determine those books my meager resources could afford. The first book I decided to purchase was Oppenheim's International Law, Volume 1, Peace. The problem was that for 5 or 6 guineas, it was by far the most expensive book on the list. Nonetheless, I went ahead with the purchase and was left with little funds to buy other books. As you know, the editor of the 8th edition of Oppenheim was the father of Sir Eli Lauterpacht, Sir Hirsch Lauterpacht, former International Law Commission Special Rapporteur on the law of treaties and member of the International Court of Justice. This lecture is named for Sir Eli Lauterpacht, and the Lauterpacht Center is named for both father and son. Hence, although I have never met either father or son, through that initial transaction, I have a sense of connectedness with both. Ladies and gentlemen, I am pleased to be here today to deliver this lecture. Part 1 focuses on the development of the right to self-determination as a rule of customary international law and its application in relation to the Chagos Archipelago, Africa, and the Commonwealth Caribbean. Part 2 addresses the status of the right to self-determination as a norm of jus cogens, and Part 3 addresses the application of the right to self-determination in relation to the occupied Palestinian territory, OPT. Mauritius was a colony of the United Kingdom, which had as part of its territory the Chagos Archipelago. In 1965, the United Kingdom detached the archipelago from Mauritius to allow the United States to establish a military base. For that purpose, it removed the residents of the archipelago, practically all Black persons whose ancestors had been brought more than 100 years before to work enslaved on the plantations of the islands. The General Assembly asked the court to, inter alia, determine whether, in light of the detachment of the Chagos Archipelago by the United Kingdom in 1965, the process of decolonization was lawfully completed when Mauritius was granted independence in 1968. On December 14, 1960, the UN General Assembly adopted Resolution 1514, Declaration on the Granting of Independence to Colonial Countries and Peoples. It is the most frequently cited resolution of the UN General Assembly and has been described as the Magna Carta of colonial peoples. It is so transformational that I simply call it 1514. And I analyze 1514 under 5 headings: the contextual framework of the resolution, the essence of the right to self-determination, the prohibition of dismemberment, the irrelevance of readiness for independence, and how colonial peoples became independent, the obligatory transfer of all powers. And paragraph 1 of the resolution neatly encapsulates the horrors of colonialism: alien subjugation, domination, and exploitation are the classic ills of colonialism, and they are to be remedied by the application, the exercise of the right to self-determination. Now, paragraph 2, which is the central pillar on which the resolution is structured, reads, all peoples have the right to self-determination. By virtue of that right, they freely determine their political status and freely pursue their economic, social, and cultural development. This is arguably one of the most consequential and far-reaching political and legal proclamations made in international affairs after 1945. Written in the present tense, this is a very categoric and emphatic statement, declaratory of existing rights that all peoples have by virtue of their humanity. In its advisory opinion, the court found inter alia that the right to self-determination was a customary norm, that the detachment of the archipelago agreed to by the Mauritian Council of Ministers did not reflect the free and genuine expression of the will of the peoples of Mauritius, and that the United Kingdom must bring to an end its administration of the archipelago as rapidly as possible. 1514 was adopted by 89 votes in favor, none against, and 9 abstentions. Roslyn Higgins, later a member and president of the International Court of Justice, after commenting on the relatively low number of abstentions, wrote that the resolution must be taken to represent the wishes and beliefs of the full membership of the United Nations. It may be concluded that the right to self-determination crystallized as a rule of customary international law on the resolutions adopted in 1960. Some argue that it achieved that state before the end of 1960. In Western Sahara, the ICJ held that the application of the right to self-determination requires a free and genuine expression of the will of the peoples concerned. This will was ascertained, where necessary, through a plebiscite or some other recognized democratic means conducted under the auspices of the General Assembly. Naturally, the General Assembly had to ensure that the territory of a country was respected in the transition to independence, to guard against action by a colonial power to dismember territory prior to independence. And so paragraph 6 makes it abundantly clear that the right to self-determination has a territorial dimension that colonial powers are obliged to respect. The unit for self-determination is the territory of colonial peoples in its entirety. The Chagos advisory proceedings turned on this very issue. For colonial African and Caribbean states, the resolution of the issues relating to their independence has been bedeviled by what I describe as the colonial doctrine of gradualism and lack of readiness. According to this doctrine, a people do not have any inherent right to independence, and it is only by a process of gradualism that they may, after colonization for 300 years or so, achieve internal self-government and thereafter independence. It appears that the Commonwealth Caribbean countries were so indoctrinated and conditioned by their colonial master to believe that they were not ready for full independence, that with the exception of Dominica, they negotiated a form of independence that retained the British monarch as their head of state. In Africa, on the other hand, practically all the former English colonies became republics upon independence. One does not need to have the acumen of St. Lucian Nobel laureate Sir Arthur Lewis to discern the reason for this difference. Paragraph 3, which reads, inadequacy of political, economic, social, or educational preparedness should never serve as a pretext for delaying independence, signifies that a colonial people's right to independence is in no way dependent on a determination that they are ready for that status. And so the great Pan-Africanist Kwame Nkrumah was right when he said, it is far better to be free to govern or misgovern yourself than to be governed by anybody else. Since the first Commonwealth Caribbean state became independent in 1962, 4 have become republics. But in 1962, these states were, in my view, as good a position as they are today to separate their governments from the British monarchy. They have not derived any benefit in the last 62 years that they would not have had were the King of England not their head of state. Today, some Caribbean states are still not comfortable with achieving full independence by removing the King of England as their head of state. And in particular, it is not unusual to hear the view expressed, and at times by a prime minister, that a Caribbean state is not ready to sever ties with the British monarchy and in effect must achieve a certain level of development before doing so. Obstructionist conduct by the colonial powers to the attainment of independence by colonial peoples would breach paragraph 5 of 1514, which requires that the exercise of the right to self-determination, reflected in the freedom of all peoples to determine their political status, is not to be delayed for any reason, including inadequate preparedness. Although the paragraph envisages steps to be taken for the transfer of all powers to colonial peoples, it mandates that those steps must be taken immediately in accordance with the freely expressed will of the peoples. Following the adoption of 1514 on December 14, 1960, it was colonized peoples themselves and not the colonizers who determined their independence and its form. Example, whether based on a republican system of government or a United Kingdom parliamentary system. Thus, after that time, the colonial powers were under an obligation to respect the right of colonial peoples to freely determine their political status, and any breach of that obligation would entail their international responsibility. Therefore, as a matter of law, the attainment by former colonies of independence was not a gift, grant, or concession from the colonial powers. Rather, independence resulted from the discharge by the colonial powers of an obligation imposed on them by customary international law to transfer all powers to the peoples of those countries in accordance with their freely expressed will. In light of the transformational development that occurred on the adoption of 1514 on December 14, 1960, by virtue of the crystallization of the right to self-determination as a rule of customary international law, it is, in my view, a misstatement of the law to assert that colonial powers granted their former colonies independence. After that development, independence was not theirs to give, grant, or concede. It cannot be maintained that you have been granted or given something to which you have a legal right and which the supposed grantor or giver is under a legal obligation to give, grant, or concede. Now, the conclusion that colonized peoples were not granted independence by the colonial powers is arrived at notwithstanding the title of the resolution, Declaration on the Granting of Independence to Colonial Countries and Peoples, and notwithstanding the use of the term granted independence in the General Assembly's first question put to the court. While the title may be relevant for the purpose of interpreting it cannot dictate an interpretation that finds no support in the text of the resolution. 1514 wrested the attainment of independence from the hands of the colonizers and placed it firmly in the grasp of colonized peoples themselves. Once the freely expressed will of the people favors independence, Article 5 is clear. The colonizer must transfer all powers to the peoples of the particular territory. Nowhere in the text of 1514 is the term grant of independence used. You can study 1514 yourself and tell me if you find the term grant of independence used in it. In short, the notion reflected in the title that under 1514, a colonial power grants independence is not supported by an analysis of its object and purpose, which is to affirm the inherent power that all colonial peoples have by virtue of their humanity to advance to independence on the basis of their freely expressed will. Ladies and gentlemen, having sat as a judge in Chagos, where the ICJ had to determine, among other things, whether the detachment of the archipelago agreed to by the Mauritian Council of Ministers reflected the free and genuine expression of the will of the peoples of Mauritius, I have given much more thought to the processes of decolonization in the also small jurisdictions in the Caribbean colonized by the United Kingdom. Between 1962 and 1983, 2 decades, 12 small countries, some with populations under 100,000 persons, became independent. Following Chagos, I asked myself whether the processes leading to and the products of the independence processes were consistent with the requirement of the norm of Yuskogans that all peoples have the right to freely determine their political status. And I ask that based on what we know about how these constitutions were made. UK officials like William Dale boasted that Whitehall lawyers must have drafted at least 33 complete and final independence constitutions during the period. Dale, himself a former legal advisor to the Colonial Office, suggests that the UK insisted on bills of rights in Caribbean constitutions because one didn't know what these people were up to. According to Sir Robert Ray, former legal advisor to the Secretary of State for Foreign Affairs, these constitutions were prepared more with scissors and paste than with pen and pencil. Evidence gleaned by researchers from now declassified Colonial Office documents confirms that there was significant British Colonial Office involvement behind the scenes in the constitution-making process. Randolph Hahn tells us that a government white paper in 1966 did in fact contain a blueprint for some Caribbean constitutions. The section was titled Outline Constitution for ... which means the particular country. The existence of a blueprint evidences, at least, in my view, an intent to participate actively in the pre-independence constitutional processes, and quite likely, an intent to ensure that the outcome of the conferences followed the blueprint. Otherwise, why have a blueprint? According to Hahn, during constitutional discussions in 1953, Nigeria suggested the inclusion of a Bill of Rights in its constitution. The colonial secretary's response was that if the Nigerians wanted to put God is love in their constitution, they could do so, but not while he was chairman. However, after the Nigerian Bill of Rights was adopted in 1959, in general, the United Kingdom insisted on bills of rights in the constitutions of its former colonies. The point is, ladies and gentlemen, whether opposing or insisting on the inclusion of a Bill of Rights in the constitution of a newly independent state, the United Kingdom was interfering with the right of colonial people to freely determine their political status. In the smallest Caribbean states, the new constitutions entrenched the jurisdiction of the United Kingdom Privy Council at the highest level, requiring a referendum to remove and replace that jurisdiction with that of another state. Astonishingly, 4 of those jurisdictions provided as an alternative to a referendum the agreement of the United Kingdom government. Provisions in constitutions significantly drafted in London that require continued imperial judicial supervision deeply entrench the same and create as an alternative the agreement of the United Kingdom government, raise at least a doubt about whether these provisions, as the ICJ put it, reflect the free and genuine expression of the will of the peoples of those Caribbean countries. Or were these provisions reproduced in multiple constitutions, the outcome of decolonization processes that were substantially constrained by UK policy and involvement? This doubt raises the question whether these 4 Caribbean states freely determined that in order to terminate the jurisdiction of the Privy Council in their countries, in the absence of a referendum, they would have to secure the agreement of the United Kingdom, their former colonial master. Does this not appear to be a classic contradiction and negation of the right to self-determination? To be clear, the United Kingdom gave its agreement in respect of Dominica and St. Lucia, and these states have now accepted the appellate jurisdiction of the Caribbean Court of Justice. But, ladies and gentlemen, would it not make a nonsense of independence if the United Kingdom had refused to agree to the termination of the jurisdiction of the Privy Council in these two states? These provisions would seem to be a prescription for dependency, not for independence. These are remarkable provisions in the constitutions of newly independent Caribbean states. The retention or termination of the jurisdiction of the Privy Council in a newly independent Caribbean state, and the retention or removal of the British monarch in such a state are quintessentially matters that engage the right of colonial peoples to freely determine their political status. It must be acknowledged that 1514 anticipated that steps would have to be taken to transfer all powers to colonial peoples in accordance with their freely expressed will. But I doubt whether 1514 ever contemplated constitutional conferences and the processes of the kind that the United Kingdom organized. Certainly, 1514 did not envisage a pre-independence conference in which the UK would have a blueprint for the constitution of a newly independent state. These conferences had a UK influence that in general would seem to run counter to the right of colonial peoples to freely determine their political status. One explanation for the paternalistic attitude of the United Kingdom in these conferences is the mistaken notion that it was granting independence to its colonies and was therefore able to determine the terms of independence. It has already been explained that 1514 does not provide for a grant of independence by the colonizer to the colonized. Once the freely expressed will of colonial peoples favors independence, 1514 obliges the colonizers to transfer all powers to the peoples of the particular country in accordance with their will. The transition to independence for Caribbean states could not escape the taint of racism that was at the heart of the colonial experience. Asked in 1962 about the motto for the failed West Indies Federation, according to now declassified colonial office documents, Hilton Poynton, permanent undersecretary, said, 10 little nigger boys. Turn now to part 2, which is the right to self-determination as a norm of Uskogans. And Uskogans literally means compelling law. According to conclusion 2 of the International Law Commission's conclusions on peremptory norms of general international law, a peremptory norm of general international law is a norm accepted and recognized by the international community of states as a whole, as a norm from which no derogation is permitted, and which can be modified only by a subsequent norm of general international law having the same character. This definition, reflecting Article 53 of the Vienna Convention on the Law of Treaties, is generally accepted. And in this lecture, I use the terms Uskogans and peremptory norm interchangeably. In its advisory opinion on the Chagos Archipelago, the court did not address the characterization of the right to self-determination as a norm of Uskogans, although a large number of speakers in the advisory proceedings, in fact, 22 of the 31 participants, described the right to self-determination as a norm of Muskogeans. The court followed its earlier characterization of the right in the case concerning East Timor as one that establishes obligations, erga omnes. But in my separate opinion, in that case, I examined the question whether the right to self-determination is a norm of Muskogeans, concluded that it is, and that it possessed that status in the relevant period, 1965 to 1968. You can see paragraphs 57 to 89 of my separate opinion. This conclusion raises the question whether the agreement concluded between the United Kingdom and Mauritius in 1966 was void for breaching the peremptory norm of the right to self-determination. It is in questions relating to the obligation to prosecute or extradite Belgium versus Senegal that one finds the clearest explanation to date of the court's view of the kind of evidence needed to substantiate a finding that a norm of general international law has attained the status of a peremptory norm. In that case, the court held that the prohibition of torture is part of customary international, and it has become a peremptory norm. That prohibition is grounded in a widespread international practice and on the opinio juris of states. It appears in numerous international instruments of universal application. It has been introduced into the domestic law of almost all states. Acts of torture are regularly denounced within national and international forums. In paragraph 70 to 73 of my separate opinion in Chagos, I set out evidentiary material supporting the Muskogean character of the right to self-determination. The material cites several international instruments of universal application, the views of states, and the views of international bodies, courts, and scholars. The evidentiary material, in part, follows the court's approach in paragraph 99, obligation to prosecute or extradite. It is to be noted that in the 5th report of the ILC's Special Rapporteur on peremptory norms of general international law, the right to self-determination is included in a non-exhaustive list of examples of Muskogeans. In 1953, during the ILC's work on ILC's International Commission on the Law of Treaties, Special Rapporteur Lauterpacht introduced draft Article 15 on treaties illegal under international law. The Special Rapporteur stressed that the voidness of such treaties was not due to their inconsistency with customary international law, but with such overriding principles of international law, which they regarded as constituted principles in international public policies. The concept highlighted by Lauterpacht, the Special Rapporteur, are implied in the formulation of Article 53 of the VCLT, the Vienna Convention on the Law of Treaties. The right to self-determination is a norm that, like obligations erga omnes, reflects principles with a moral and humanitarian underpinning and which serve a wider public communitarian purpose. Its principal feature of non-derogability is recognized and accepted by the international community of states as a whole, even without a conventional obligation to do so. Its universality is reflected in its application to all states. It is a norm that protects one of the most fundamental values of the international community, what the court in Barcelona Traction calls the basic rights of the human person, which include the obligation to respect the inherent dignity and worth of every human being, which in my view is the basis of the right of peoples to freely determine their political status. In sum, the evidentiary material shows that the customary right to self-determination has become a peremptory norm of general international law. So let us now examine the impact of that conclusion on the Chagos case. On December 30th, 1966, the United Kingdom and the United States adopted an exchange notes constituting an agreement concerning the availability for defense purposes of the British Indian Ocean Territory. I refer to this as the 1966 agreement. And paragraph 2 reflects the position of the parties that the islands shall be available to meet the needs of both governments for defense. An agreed minute of the same date between the two states indicates that there was an understanding that the administrative measures that the United Kingdom was required to take in respect of the islands were those necessary for modifying or terminating any economic activity then being pursued in the islands, resettling any inhabitants, and otherwise facilitating the availability of the islands for defense purposes. Ladies and gentlemen, the 1966 agreement conflicts with Hughes Hogan's norm of the right of the Marine, including the Chagosians, to self-determination, because the establishment of the defense facility on the Chagos Archipelago, the removal of the inhabitants of the island, a consequence of the establishment of the defense facility, and the resettlement of the Chagosians did not reflect the free and genuine expression of the will of the people of Mauritius, including the Chagosians. And these are all matters that fall within the scope of the General Assembly's second question. In that question, the court was asked to determine the consequences under international law arising from the continued administration by the United Kingdom of the Chagos Archipelago, including with respect to the inability of the Mauritius to implement a program for the resettlement on the Chagos Archipelago of its nationals, in particular, those of Chagosian origin. So let us now look at the consequences in the law of treaties of the breach of the Hughes Hogan's norm of the right to self-determination. By virtue of Article 53 of the Vienna Convention on the Law of Treaties, which reflects a customary rule, the 1966 agreement, which conflicts with the Hughes Hogan's norm of the right to self-determination in the manner described above, is void. Consequently, the provision in Article 71 of the VCLT applies, and I'll read it to you. In the case of a treaty which is void under Article 53, the parties shall, A, eliminate as far as possible the consequences of any act performed in reliance on any provision which conflicts with the peremptory norm of general international law, and B, bring their mutual relations into conformity with the peremptory norm of general international law. So in accordance with this article, the United Kingdom and the United States would be required to terminate, by which I mean dismantle, the defense facility, because it was established in reliance on the 1966 agreement. They would also be required to repatriate the Chagosians to all their islands, including Diego Garcia, on which the defense facility was established. Ladies and gentlemen, the right to self-determination is a human right from which no derogation is permitted. As stated in the 1952 General Assembly Resolution 637 and confirmed by the Human Rights Committee in its 1984 General Comment number 12, the right to self-determination is a prerequisite to the full enjoyment of all human rights. The Human Rights Committee explains that it is for that reason that states placed the right to self-determination as Article 1, apart from and before all of the other rights in the two covenants. You know, the two covenants are the International Covenant on Economic, Social, and Cultural Rights, and the International Covenant on Civil and Political Rights. And Article 1 of both conventions reflects the same right to self-determination that you see in 1514 in the very same language. Now, the fact that the 1966 agreement for this provides for the establishment of a military facility is an irrelevant consideration that must yield to the non-derogable right to self-determination. As Sir Eli Lauterpacht explained in a separate opinion in the 1993 genocide case brought by Bosnia and Herzegovina against Serbia, even a Security Council resolution, which is to be applied in accordance with Articles 25 and 103 of the UN Charter, must yield to a jus cogens norm if it conflicts with that norm. And so the 1966 agreement, which conflicts with the jus cogens norm of the right to self-determination, is rendered void by reason of this conflict. But there is, in my view, another basis for rejecting the 1966 agreement. It is difficult to resist the conclusion that the treatment of the Chagosians resulting from the implementation of this agreement was prompted by considerations sufficient to constitute a breach of the International Covenant on the Elimination of Racial Discrimination. This is the advice the court would have given the General Assembly in answer to the second question, had it proceeded to consider the jus cogens character of the right to self-determination. So let us look now at the consequences in the law of state responsibility. Having looked at the consequences in the law of treaties, we now look at the consequences in the law of state responsibility of a breach of the jus cogens norm of the right to self-determination. So it is well known, Chapter 3 of the ILC's articles on state responsibility addresses serious breaches of obligations under peremptory norms of general international law. Article 40, paragraph 2. Under Article 40, paragraph 2, a breach of such an obligation arising under a peremptory norm of general international law is serious if it involves a gross or systematic failure by the responsible state to fulfill the obligation. It is beyond question that the United Kingdom's detachment of the archipelago from Mauritius constitutes a gross failure on its part to fulfill its obligation in relation to the peremptory norm of the right to self-determination. Article 41 imposes what the commentary on this article calls a positive duty on states to cooperate to bring to an end through lawful means any serious breach of an obligation under a peremptory norm. And it also obliges them not to recognize as lawful a situation created by a serious breach, nor to render aid or assistance in maintaining that situation. The court would also have given advice to the General Assembly based on the above mentioned ILC articles on state responsibility. Now, on October the 3rd, 2024, the UK and Mauritius issued a joint statement indicating that they will enter into a treaty whereby the UK would give up sovereignty over the Chagos Islands, including Diego Garcia, to Mauritius, allowing the displaced Chagosians to return to the islands. However, the UK-USA military base on Diego Garcia would remain for an initial period of 99 years. The UK will exercise, with respect to Diego Garcia, the sovereign rights and authorities of Mauritius, required to ensure the operation of the military facility. In effect, Mauritius will not enjoy sovereignty over Diego Garcia for at least another 99 years. The Chagosians will not be allowed to resettle on Diego Garcia, which many of them called home. In my view, this forthcoming treaty will do an injustice to the Chagosians. It has already been explained that the 1966 agreement to establish the military base is void for breaching the parliamentary norm of the right to self-determination, and that the defense facility should have been terminated. Following the termination of this facility, the Chagosians should have been allowed to return to the islands of the archipelago, including Diego Garcia, where they had previously lived. And so by my analysis, the forthcoming treaty to extend the defense facility for another 99 years is not reached. We don't reach it because the facility should have been dismantled, in my view. So let me turn now to the last part of my comments, the application of the right to self-determination in relation to the occupied Palestinian territory. The General Assembly sought the court's opinion on the following questions. A, what are the legal consequences arising from the ongoing violation by Israel of the right of the Palestinian people to self-determination from its prolonged occupation, settlement, and annexation of the Palestinian territory since 1967, including measures aimed at altering the demographic composition, character, and status of the holy city of Jerusalem, and from its adoption of related discriminatory legislation and measures. B, how do the policies and practice of Israel referred to in paragraph 18 above affect the legal status of the occupation? And what are the legal consequences that arise for all states and the United Nations from this? So you may be disappointed. I don't intend to get into the nitty-gritty of this issue. I have one main interest in this advisory opinion. It is how it treats the question of the parliamentary character of the right to self-determination. And you can see that I have quite an interest in that issue. So let me turn immediately to the tweet. In paragraph 233 of the advisory opinion, the court found that in cases of foreign occupation, such as the present one, the right to self-determination constitutes a peremptory norm of international law. And this is a departure from the position the court took in Chagos, when it declined to consider whether the right to self-determination was a peremptory norm. In the court's finding in the OPT, we see once more OPT occupied Palestinian territory decision. We see once more what I described in paragraph 60 of my separate opinion in Chagos as a slight hesitancy of the court to become engaged in a discussion of the norm of Yuskogans. And we also see what Judge Clady in paragraph 15 of his declaration in the OPT described as the court's historical reluctance to recognize norms of Yuskogans and to acknowledge that the right to self-determination was such a norm. This hesitation helps to explain the qualified manner in which the court recognized the peremptory character of the right to self-determination in the OPT. It would seem that this historical reluctance resulted in a compromise formulation that leaves us with a puzzle as to what it means. It does not mean what it appears to mean, that is, that in cases of foreign occupation, unlike the occupation in OPT, the right to self-determination is not a peremptory norm. Still less does it mean that the right to self-determination does not constitute a peremptory norm in cases which do not involve occupation, but in which peoples are subjected to alien subjugation, domination, and exploitation. Apparently, it means that in cases of foreign occupation, such as the OPT, the right to self-determination is undoubtedly a peremptory norm of international law. In my view, matters would have been clearer had the finding in paragraph 33 of the advisory opinion been formulated as follows. In cases of foreign occupation, including the present one, the right to self-determination constitutes peremptory norm of international law. The court's confirmation of the peremptory status of the right to self-determination supports the view expressed in my separate opinion in Chagos on this issue. In my view, the peremptory character of the right to self-determination is engaged and breached in any case in which a people's right to freely determine their political status and freely pursue their economic, social, and cultural development is denied or obstructed by alien subjugation, domination, and exploitation, even if the foreign domination is not characterized by occupation or occupation of the kind in the OPT. And thus, the peremptory character of the right to self-determination would be engaged and breached if the United Kingdom, France, or the Netherlands obstructed the freely expressed will of the peoples of their Caribbean overseas territories for independence. It will be observed that in its opinion, the court makes no use of its finding that the right to self-determination is a peremptory norm of international law. And so you may say that the finding appears to have a formal and obiter character. The court's finding, in my view, ought to have led it to apply Article 41, ILC's articles on state responsibility, to which reference has already been made in relation to Chagos. It may be recalled that this article addresses the duties of non-recognition, non-assistance, and cooperation as consequences of a serious breach of an obligation arising under a peremptory norm of general international law. But in considering the legal consequences for other states of Israel's international wrongful acts, the court made no reference to the peremptory character of the right to self-determination, but instead observed that the obligations invited The obligations violated by Israel include obligations ergo omnes. This observation raises interesting questions which constraint of time does not allow me to address. In conclusion, ladies and gentlemen, while I welcome the court's treatment of the right to self-determination as a peremptory, itself an advance on the position it took in Chagos, I am bound to repeat what I said in paragraph 82 of my separate opinion in Chagos. The court's embrace of the concept of Eustochians is somewhat hesitant. And I might now add, it is rather like two lovers unsure of the affection one has for him. Thank you.